afternoon, everyone. On behalf of Insolvency and Valuation Standards Board of the Institute of Chartered Accountants of India, I welcome you all to this webinar on a very important topic, which is Interplay of IBC with MPID and Competition Act, deep dive into NSEL and HNG judgment of the Apex Code. We have with us today CA Gyanchand Mishra sir, who is the chairman of Insolvency and Valuation Standards Board and leading the board from the front, who is taking care of all the activities of the board. Then in absentia, CA Rajesh Sharma sir, who is the vice chairman of our board. Also, we have with us today's speaker, Mr. K. Sivalingam sir, who is the insolvency professional in this case. Then we have from our Advocate Y. Surya Narayanan sir. And we have TAS Badri Narayanan sir, who was also part of this judgment. With these words, I would request Gyanchand Mishra sir to give his remarks, opening remarks. Welcome to you, sir.
Thank you. Thank you so much, Sarika. Very distinguished speakers of this today's webinar on very important topic, interplay of IBC with MPID and Competition Act. All the three respected speakers, K. Sivalingam sir, Surya Narayan sir, and of course, my good friend Badriji, and all respected participants, good afternoon to one and all. Friends, we understand that the dynamics of the IBC is changing very fast as of now. If we see, on the one hand, so many judicial pronouncements are impacting the overall ecosystem of the IBC. On the second hand, the recent judgment with respect to the Bhusan is creating new buzz in the market. So, being insolvency professionals, we have to keep ourselves updated with the latest development of the judicial pronouncements, rules and regulations, and of course, the recent amendments that are being undertaken by the regulators. Friends, profession of the insolvency professional is certainly very challenging in the time. If we see the control of the committee of creditors on the one hand and responsibilities and duties of the resolution professional to the other hand, is making a great imbalance in the working of the insolvency profession. Now the time has come when the regulators have to creep in and they have to
Cancer, we are losing your voice. Cancer.
Some balance.
Network issue. Yes.
Okay. Are you getting now?
Last 10 seconds.
Are you audible?
Yes, sir. Yes, sir.
Now audible?
Yes, yeah. Now audible. Now audible.
Okay. So, friends, recently we had 2-3 meetings with the regulators also, where we requested them to intervene and to come up with some of the regulations so that the insolvency professionals who are very little in numbers, looking the size of the to their professional.
Gyan sir, we are losing your voice, sir, again and again, just to inform you. Ma'am, I think because he's driving. So.
Case. One very important case. And all the three respected, speakers, they are part of the case. So we understand that today's webinar is going to help the professional to understand the deep dive that is going to be discussed today. In the meantime, I'll request Sarika madam that recently the Bhusan case which has been decided, that is again probably retrospective, if I am correct. So one session on that we should plan very soon so that the members can understand the impact of the judicial pronouncement that the verdict has been given by the Honorable Apex Court. So without taking much time, once again, I welcome all the respected speakers and participants and friends. For information of all, we are going to have one international, webinar very soon. And in that we are explaining, like earlier, more than 12,000 insolvency professionals across the globe were benefited from the webinar. Very soon we are going to have one international webinar speakers as well as the issues of the intercontinental, inter-region that shall be discussed. And I hope that the members get benefited. The last thing, resource person for the board may kindly send their mail to the committee, whether as a writer, as a speaker, as contributing to the monthly newsletter, in any manner, whatever you can contribute, please help the board to make the working of the board more effective and more valuable. So thank you one and all for patient listening, and I once again welcome all of you. Thank you very much.
Thank you so much, sir, for your encouraging words and also requesting the members to participate in the activities of IVSB, as well as also to inform them about the next webinars we are planning on the subject. With this, now I would like to take a minute to introduce our speakers today. We have with us Mr. K. Sivalingam, sir, who's an insolvency professional. He is a seasoned banker and RP liquidator with 3 decades of service in the banking sector, holds a master degree in mathematics. He has worked with State Bank of India and retired as a DGM after completing 32 years of service. He has more than 5 years deep corporate experience in handling lending institutions and bankers. Also, he has handled various sectors like automobiles, telecom, textiles, oil shipping, and power during his tenure as banker. Welcome to you, sir. Now we have with us C.S. Badri Narayanan, sir, who is a chartered accountant. He is our special invitee. He also has done certification in forensic accounting and fraud detection. He is a seasoned professional with extensive expertise in the fields of insolvency and bankruptcy code. He has contributed to the professional and international community through articles published by ICAI, ICSI, FTCCI Review, Directors Today, and International Corporate Service. Welcome to you, sir. Now I would like to introduce Mr. Y. Surya Narayanan, who is an advocate and is a corporate law practitioner with rich and diverse hands-on experience in handling a variety of legal cases involving complex issues. He has also rendered a wide spectrum of functions and service related to capital markets, corporate law, insolvency law, and strategy. Apart from appearing and representing clients before various courts, he handled a variety of assignments. Then now his area of practice is he is representing and appearing before Supreme Court, High Court, NCLT, NCLAT, adjudicating authorities established under various laws. With this, I welcome to you, sir, with your wide experience. Now I hand over to C.A. Badri Narayanan, sir, for taking this session along. Once again, welcome to you all.
Thank you. Thank you, Sarika ma'am. Thank you, Gyan sir. Thank you to the chair, vice chair, IVSB, to the institute for organizing this very important webinar on this crucial subject. Thank you, Sarika ma'am, for coordinating this webinar for us. So to just set the context, a very good afternoon to all the participants. First of all, on a working day, you are spending time with us, and we'll make sure that your time is well spent and you learn something, and we also learn something from you when the webinar ends. At the outset, I just wanted to set the context of this webinar and why it is important. So the our webinar is titled NSEL and HNG Judgement, but it is not about the judgment per se. It is about the interplay of IBC with various enactments like MPID Act and Competition Act. MPID Act being a state act, and then you have Competition Act, which being a central act. Now we know the purpose of IBC is for revival and to make the. Is it okay, Sarika ma'am, for you?
Yes, sir.
I think Sivalingam sir, you may have a network issue.
Now it's okay.
Yes. So the purpose of IBC has been revival and making sure the corporate debtor stands on its feet, and the going concern and protection and preservation of value of assets of the corporate debtor. But while an insolvency professional does that role, while he conducts CRP in a corporate debtor, he may be faced with many kind of interplays. We have seen the interplays with Customs Act, Income Tax Act, and Revenue Recovery Act. There are so many interplays of IBC happening, and IBC is evolving. It's a new subject. It will take time to establish jurisprudence. We are just entering the 10th year now, and the judicial precedents are also helping in evolving the literature in IBC. But when such interplays happen, obviously new challenges come to the forefront. We understand new practical issues which are coming, and we try to find out solutions to those issues and try to work out in the best manner as possible as an insolvency professional. So this case, we'll focus more on the MPID case because we were part of the case somewhere, and we'll be able to throw more light and insights on it for the better valuation of the participants. We'll also touch base upon the HNG case, the Competition Act. Very briefly, we'll take the participants through that also. But more focus on the MPID case because Mr. Sivalingam sir was insolvency professional in one of the entities which faced the very attachment from in MPID, and which was a party in Honorable Supreme Court's case. And Y. Surya Narayana sir was the counsel, and he's been assisting the RP. And I was part of RP team for a considerable time, and I've handled the case end to end. I briefed the senior counsel also on this. So we will be able to give some insights as to how it practically unfolded, and what were the issues faced by the IP, and what kind of things an IP should keep in mind while he faces such issues, and so on and so forth. So we'll touch upon those. We'll touch upon the provisions of MPID. It's very important that the participants are first made aware of the role of IP, and because that sets the context as to where the role is getting conflicted. Then the provisions of MPID, because that shows that why your conflict is coming with some other act. Then the provisions of IBC, just to the extent where the conflict is arising. Then we'll talk about what the NSEL case was. What was the entire financial issue which arose in NSEL, and how it led to a writ petition in Supreme Court, how that led into a Supreme Court committee being formed under Article 142 of Constitution, which is again part of the judgment which we are going to discuss, and how that committee issued an order on a question of law, and how that order culminated into an appeal in Supreme Court, by which we have this judgment dated 15th May 2025. And this judgment obviously is going to be very crucial because it will impact all the cases where MPID attachments were there, and it may also be used as a precursor in other areas or other aspects where a state act is some authority under a state act is attaching the properties of the corporate data. So with this, we'll start the session, and I'll request Mr. Sivalingam sir to start the session. I'll project the slides, and he will start by talking about the role of IPs and the object of IBC for IPs. Sir, let me know once you are able to see my screen, sir. I think it should be visible, sir, full screen.
Yeah, it is visible.
It's visible.
But it's not there for me.
It's there, sir?
Now only, yeah, now it's coming.
Okay. Sir, I request you to take it forward, sir, with the role of IP.
Thank you, Badri. Good evening to everybody, sir. My sincere thanks to ILVSB for giving me an opportunity to participate in this webinar. I will discuss about what is my role in this NCS case versus NSEL and other cases. So first of all, this primary purpose of IBC is to protect the interests of the creditors, streamline the insolvency process, and maximize the value of the company's assets. This is achieved through a time-bound and transparent process that encourages corporate restructuring, and the last resort is only the liquidation. It encourages revival of companies. So let me go one by one. That is under section 12, the maximum period was given as 180 days and plus 90 days plus another 60 days.
total 330 days. In our case, though, we are crossing all this timeline because we could not complete our CRP process within this timeline due to various litigation in various courts in NCLT, NCLAT, and of course SEC and Supreme Court and the PMLA Appellate Tribunal. I'm coming to section 13, 14, 15 as an ERP and RP. The following duties we have completed. That is collecting information from various people, receiving and collecting claims, and forming COC also, then monitoring assets and managing operations, filing information with information utility, and of course taking custody, first and foremost taking custody and control of the assets of the company, what are available in the balance sheet, preserving and protecting the assets, representing the CD in all cases, and managing the finance, going for interim finance or CRP contribution from various COC members, engaging various professionals to assist me, of course, legal people, accounting people, etc. And of course, all the claims are received and collected and verified, and claims have been verified and admitted also. And I'll go to section 18 and 25, where the duties of RPs and IRPs, RPs, whatever I told earlier now. And information memorandum was prepared under 29, in which all the details of latest financial list of creditors, debtors, guarantee, litigation, employees, and all the aspects are given in the information memorandum. And of course, the expression does from in NCS cases from more than 13 people. But it's out of 13 people, 4 people have submitted the resolution plans, but after that 2 is finalized. But unfortunately, due to various litigations, COC could not finalize the resolution plan because the resolution plan value is much less than the liquidation value. And that's why we could not complete our CRP process even within the 330 days still going on. Finally, now this Honorable Supreme Court decision on 15th order is again continuing, and recent meeting in COC, COC recommended for review petition before the Honorable Supreme Court. And of course, the assets of the company were attached by various litigation. First of all, the revenue required district collector sold property before CRP, and after CRP during moratorium also he has sold some properties. We have gone to NCLT to protect those assets, but we got the federal order in NCLT, but the buyer has gone to NCLAT. That is still going on. Similarly, MPID Act also, under MPID Act also, some lands were attached and some lands are sold during moratorium. Again, we went to NCLT. We got some federal orders. I'm subject to Supreme Court order. And again, now PML Appellate Tribunal is still going on. And unless these things are coming in our favor, we cannot conclude this CRP process. That's where the stage is there. So we are facing a lot of issues on litigations. That's why it is still continuing. Of course, kind of funding issues are also there. Some of the COC members are not giving the funding also. We are facing a lot of problems with the employees for salary, non-payment, and all. So with this, now I will conclude because this is mainly the legal issues. I will ask Mr. Badri and Mr. Suryanarayan to take over, sir. Mr. Badri?
Sir, we have lost you.
Is it okay now?
Yeah.
Yes. When I go full screen, it's not enabling me to toggle the functions. Sorry for that. Thank you, sir. Thank you, Shivalingam sir. We just wanted to add on to a couple of pointers here where Shivalingam sir has explained regarding functions of RP. So why we wanted to touch upon these particular provisions is because these will relate to the conflicts which you are going to learn about or read about. The timeline of CRP is very important, that because IBC says 180 days, right? And when you go in an MPID case, that's going to stretch for probably many years. And when you go for a competition approval, that again has its own timeline. So it becomes very difficult to fit in the IBC timeline with other timelines. So it's again important that at least we try to adhere to our timeline, the IBC timeline, because that has been a cause of concern in recent days where resolutions are spanning across years and the timeline is not being respected. There can be reasons which are not in our control, but of course, whatever is there in RP's control, that should be done to optimize the timeline. And then coming on to public announcement and moratorium, why again this is important is it has been held very clearly that CARP is a proceeding in REM. Once it starts against all the stakeholders. In fact, now there is a regulation which says that a public announcement, when it's done, and you have to intimate creditors. Once you get books of account from the company, you have to intimate all the creditors. But if you don't get that address also, it is deemed that it is in their knowledge, because by way of public announcement, you have given a constructive notice. And when this constructive notice is there, an RP may as well take a stand before some court where he was not even aware that a proceeding is going on, that he has done a public announcement. So it's very important that RPs who come over as IRP get appointed have to follow these provisions mandatorily to make sure that the moratorium provisions are enforced strictly. Then coming on to management of affairs, duty of IRP and management as a going concern. These are important because these are the roles as an RP we are expected to do. If there are no assets to take custody and control of, then what am I going to run the CRP for? Hence, these provisions give the power to the IPs to take custody and control and to manage the company as a going concern. And these powers get in conflict when there is some other power to some other authority in some other law. Then you come to information memorandum and plan.
Padri sir, now you can try for making it full screen.
I'll try.
Now it's okay, sir.
It's okay, yeah. So then coming on to information memorandum and submission of plan. So in an information memorandum, we have to capture the asset base of the company along with other items which are prescribed under law, like material litigation, guarantees, and so on. But we have to capture the asset base. It is like a pitch document you're going to prepare and give to the PRAs and even to the COC, and that is what is going to help you revive the corporate data. And in information memorandum, if I'm not aware what assets I can put, that creates a large uncertainty. In fact, this uncertainty then drags on to the potential resolution applicant as well. That uncertainty then reduces the leverage which a COC has to negotiate with the potential resolution applicant. So a lot of doubts and vagueness are created when, as an RP, you're not sure what asset base the company can put in its information memorandum and what can be sold as part of going concern of the corporate data. And obviously, when the plan is then put before COC and it's approved, it becomes like a contract between the COC and PR and the stakeholder. And when it's approved by NCLT, it is binding on all the stakeholders. Now, this particular aspect has been held by judicial precedent, including Honorable Supreme Court, that a plan once approved is binding on all stakeholders, including government and other local authorities. Then you have Section 32A also, where you are using Ghanshyam Mishra judgment of Apex Court, you are able to pick up the company in a clean slate. So while these things are there, while binding nature of plan is there, while Section 32A is there, while RP is empowered to take custody and control of asset, still an RP may face problem when it comes to ascertaining whether an asset is for the CD or not, because of the attachment under some other state law. And RP may do a lot of actions which are in the interest of stakeholder as per IBC, and he has immunity under Section 233 as well. So that's why it's important for us to know at least the essence of these provision whenever a conflict comes with other laws. Now, I'll request Mr. Surya Narayana to take us through the broad legal framework for MPID and then following it by IBC, because it's important we understand MPID provisions first. Surya sir, over to you.
Yes, a very pleasant morning to all the participants. And at the most outset, let me thank the Institute of Chartered Accountants, for inviting me as a speaker here. Chartered accountants profession is one profession which I respect the most. And, being a BCom student, I'll just take 1 minute on this. Being a BCom student, when I used to prepare along with other senior chartered accountant friends, it would take more than half an hour for me to understand the problem in the question paper in the CA, whether it is partnership accounts or marginal costing. And I used to wonder how they would solve it in 3 hours, because for understanding itself, it takes 30 minutes or 45 minutes for me. So you are all one of the best brains in the country. And it is my proud privilege and honor to address, all of you.
So if you had become a chartered accountant, where would we all go, sir? Sorry, but it's good that you are an advocate, sir. Yes, sir.
Thank you, Badri, for that. And then, if we see the preamble of, in fact, the MPID Act, in fact, it is an act to protect the interest of depositors in the financial establishments and matters relating to thereto. So, because where the financial establishments have been collecting monies and then they are not repaying, and there were scams, that were occurring, and defaults that are taking place. Therefore, in order to curb these practices where gullible, innocent investors are being duped by these unscrupulous financial establishments, with protection for the protection of the interests of the depositors, with this sole objective, the MPID Act has been enacted, and it is an act which is promulgated by the state legislature of the Maharashtra, and this act, falls under the entry 1, 30, and 32 of list 2 in the seventh schedule. As you are all aware, there are distribution of legislative powers between the central government and the state government. We have a federal structure. So under the constitution, under the seventh schedule, we have three lists. One is list 1, which is the union list, and the second one is list 2, which is the state list, and the third list is the concurrent list. So now, insofar as list 1 is concerned, now the union list, all the subjects which are enumerated under list 1, it is under Article 254. It is the Union of India, the Parliament, which will have the lawmaking powers. Now, insofar as both the 246 and 254, if we read together, they give the distribution of legislative powers between the union and the states. Now, insofar as the state list is concerned, now it is the legislature which has the powers to make the law. And insofar as the concurrent list is concerned, again, both the laws are, of course, subject to the provisions contained in Article 254. Now, the next slide, Badri. Yes. So, MPID Act, if you take MPID Act, it says that it defines as to, in fact, what is a deposit. Because it is for the protection of the interests of the depositors. The term deposit is important here in the sense that it includes and shall be deemed to include not only any receipt of money, but also of any valuable commodity by any financial establishment. Again, the term financial establishment also has been defined under section 2D, which means any person. It is any person accepting deposit under any scheme or arrangement or in any other manner. He has captured it here, in any other manner, but does not include a corporation or a cooperative society. So any person accepting these kind of monies and accepting a deposit is a financial establishment. And then now it is the section 3, which is the charging section. Now this says that there will be a conviction of every person, including promoter or director, responsible for the management or conduct of the business or the affairs of the financial establishment, which has fraudulently. When does this charging section come into play? It is when it has fraudulently defaulted. You have made a promise, you have collected a deposit, and you have either defaulted in payment of the same, you have not kept your promise upon its maturity. Then section 3. So it says that any financial establishment which fraudulently defaults in any repayment of deposit on maturity, along with any benefit in the form of interest, bonus, profit, or in any other form as promised or fraudulently fails to render service as assured against the deposit, then every person, including the promoter, partner, director, manager, or any other person or an employee responsible for the managing of or conducting of the business of the affairs of such financial establishment is liable for conviction. So, section 3 is the charging section, and then this is an important section, in fact, which has been considered by the Supreme Court in the recent case, in this case of NSEL. Now, section 4, it contemplates the attachment on the properties of the financial establishment, say where a default occurs. So, if a default occurs, if a complaint is received from the depositors, then if the state government is satisfied that any financial establishment has failed to return the deposit or fulfilled or failed to fulfill its promise or the assured benefit, then the government may attach either the money or property acquired by the financial establishment out of the deposit. Now, the provision further states that if such money or property is not available to be attached, then even the property of the financial establishment or the promoter, director, partner, manager, or member may be attached. So it is under this provision that by way of a notification in the State Gazette that the government issues an order of notification. Now, section 5, it contemplates the appointment of a competent authority, and then it is by way of again a notification. The government has power to notify as to who's the competent authority to exercise the control. That competent authority will execute the will be the competent authority to implement the provisions of this act. And then we go to section 6, under which a particular court is designated as a court to try the processes, procedures, and the offenses committed under this act. That will be the trial court. And then section 7 is another important provision, which in fact says that after the making of the order attachment, then, and it is under section 7 that the order is made absolute. So the competent court here the designated court will issue a show cause notice as to why the properties which have been attached should not be made absolute. Whether the properties can be made absolute, like under the PMLA Act, under the Prevention of Money Laundering Act, you have section 5 and then section 8, the confirmation of the attachment. Similar to section 5 and section 8 of the PMLA, we have section 4 and 7. So section 7 also states that the subsection 4 of section 7, it says if the designated court shall, if no cause is shown and no objections are made under section 3 on or before the specified date, pass an order making the order attachment absolute. It can make it absolute and issue such direction as may be necessary for realization of assets. And then also it says that after investigation, the designated court can also pass an order that either the attachment is made absolute, or it can be varied, or it can cancel even the order of attachment under subsection 6. So section 4 is the first part, and under section 4 the property is attached, and there is something called a word used here that the property will vest. I think it is there in subsection 2 of section 4, where it says that on publication of the order of attachment, all the properties and assets of the financial establishments and the persons mentioned therein shall forthwith vest in the competent authority. So the properties where, if the property is attached under section 4, subsection 1 says that it can be attached. Subsection 2 says that once the attachment is made, the properties will vest. Now, this word vest has some significance and importance, because this is what has been addressed in the Supreme Court judgment. And then
So allow me to project the act also, so that when you're taking the participants through,
yeah,
let me project that. So
I think Badri,
yes, sir.
If we can discuss the facts of the case,
Okay.
and then come to these provisions, I think they will be able to establish connect better, because these are the facts, and this is how the law has been applied, and these are what are the provisions, and this is how the law has been applied. Then we can go through. Just you can maybe cover the facts, so that. But I'll quickly just quickly finish this. You can also maybe share the section 4. Yes,
I'll share section 4. 1 second.
Yeah. Maybe subsection 2.
Just let me know once the screen is visible, sir.
Yeah. Yeah, section 4, we can show subsection 1 also. So, yeah. So this is where it says that notwithstanding anything contained in any other law for the time being in force. Please note this. This has an overriding effect. It says that notwithstanding anything contained in any other law for the time being in force. Okay, but please remember, this is a state enactment. Okay, but this says that upon the complaints received, that there is a default, they have failed to return the deposit or pay the interest, or to provide, the service promised against such deposit, etc. Then when the government is satisfied that such establishment is not likely to return the deposits or make the payment of interest or other benefits, then the government may, in order to protect the interest of the depositors, kindly note that it is the interest of depositors of such financial establishment, that after recording reasons in writing, issue an order by publishing it in the official gazette, attaching the money or other property believed to have been acquired by such financial establishment, either in its own name or in the name of any other person, from out of the deposits collected by the financial establishment. Now, the monies would have been collected, but their deposits may not be existing there in the form of bank deposits with the financial establishment. Now, they would have been spent, they would have acquired the assets or whatever. So that is the reason why the section says that it is not only the amounts that are available, but also the properties owned by the financial establishments, or even the assets of the promoters, partners, etc. That can be promoter, director, partner, manager, or member, that can be attached. Now, so subsection 2, it says that now on publication of the order, all the properties and assets of the financial establishment and the persons mentioned therein shall forthwith vest. This word vest, vest in the competent authority appointed by the government, pending further order from the designated court. So kindly see that this is pending. This is like a provisional attachment under section 5. So it awaits a further order. So then we move on to section 7. So under section 7, the designated court, after the attachment has been made, upon receipt, because under section 5 there can be an application. Kindly see, the government, while issuing the order under subsection 1, appoint any of its officers. Then the competent authority shall have the powers for carrying out the purposes. Now, kindly see subsection 3 of section 5. The competent authority shall, within 30 days from the date of publication of the said order, apply to the designated court accompanied by one or more affidavits stating the grounds on which the government has issued the said order under section 4, and the amount of money or other property believed to have been acquired out of the deposits, and the details, if any, of persons in whose name such property is believed to have been invested or acquired, or any other property attached under subsection 4, for such further orders as found necessary. So, first of all, subsection 2 states that this is an attachment which is pending further orders from the designated court. Now, under subsection 2 of section 4. Now, under subsection 3 of section 5, it says that the competent authority shall make an application within 30 days for further orders. Now, the stage moves on to section 7. So, upon receipt of the application which we have received, referred just now, upon receipt of an application under section 5, the designated court shall issue to the financial establishment or to any other person whose property is attached and vested in the competent authority by the government under section 4, a notice accompanied by application and affidavits of the evidence, if any, recorded, calling upon the said establishment or the said person to show cause on a date to be specified in the notice why the order of attachment should not be made absolute. So, there is a possibility that this order may not be made absolute. This order may be cancelled. So, it is in this context that we have to see that whether what is the meaning of the vesting of the property which is mentioned in subsection 2 of section 4. So, then after the hearing and after conducting an inquiry, under subsection 6 of section 7, either the attachment can be made absolute, or it can be modified, or it can be cancelled. All three can happen. It can be made absolute or modified, or the saying that this attachment is not valid, the attachment itself can be rendered invalid. And then if we move on further, then this act also has an overriding effect, under section 14, which says that save as otherwise provided in this act, the provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or any custom or usage or any instrument having effect by virtue of any such law. So this has a non-obstant clause, an overriding effect. So this law can override all the laws. But please remember, this is a law which is enacted by a state government under a subject which is falling under the list 2, the state list, and this act was passed in the year 1999. So this act was passed in the year 1999. Now, Badri, please explain the facts. Either you can or I can. Whatever the facts of the case, and so that we can discuss the interplay between these two, and then the judgment that has been rendered, how it has traveled also.
Perfect, sir. Perfect. Thank you for explaining it. It felt like I'm sitting in my law school and listening to you as a teacher. Thank you so much for that, sir. Just wanted to add on again to whatever you explained. So there is a mix of civil and criminal action intended in MPID Act. And as we all know, IBC moratorium can very well cover the civil actions. It may not cover the criminal action, although P. Mohanraj judgment says that, quasi criminal action are also covered. But it's safe to say at least that civil actions are covered. So any attachment in a civil nature, because here also if you read the provisions, it says that if any show cause is shown, then the court shall follow summary procedure under civil procedure code. So any civil actions on the assets of the company may definitely come under the contours of moratorium, and that is one of the points we did try to put before Honorable Apex Court. Now I'll just screen share my slides again. Yes. So, and to add on to what sir said, the MPID Act, so it's a state enactment. As on date, you have at least 15 plus 1 in unitary, 15 in states and 1 union territory, there are Protection of Interest of Depositors Act, which is to protect the depositors, like some chit fund scam happens, some other deposit scam happens. So it is for interest of the depositors. We have two crucial judgments in this area. There are many, but we would like to touch upon two crucial judgments. One is Apex Court judgment in KK Bhaskaran versus the state. Here, Honorable Supreme Court had upheld the constitutionality of Tamil Nadu Interest of Protection of Depositories Act, which covers Tamil Nadu and Pondicherry. And they said that provisions are very similar to MPID Act, and the pari materia they will applicable. So the question of challenge under Article 14, 19, 21, they were set aside, and it was held to be constitutional. Then we have a crucial judgment of 63 Moons Technology. In fact, if this case is read properly by anybody, they will understand the entire model of NSEL, how NSEL used to operate, what was the financial issue which arose in NSEL, how it became a financial establishment, and what are the models of trade which they use, and also about MPID Act, what is the framework of MPID Act. So this is a very good judgment to get a very good grasp on MPID Act provisions. So in this case also, the constitutionality of the Maharashtra Protection of Interest of Depositors was upheld. This came before Supreme Court because Honorable Bombay High Court had quashed some of the attachment orders which were issued by Maharashtra government. Hence, it went to Honorable Supreme Court, and Supreme Court upheld MPID to be constitutional. It said that 63 Moon Technology, which was promoter of NSEL, it upheld 63 Moon Technology to be a financial establishment, and it validated the attachment. So these two judgments are very important. Now, just Surya sir, with your permission, 3 sections which connect with the MPID provisions which we spoke.
That is what I want.
Yes. Yeah. Section 14 of IBC, which talks about moratorium. In this specifically 2 clauses, there is a as on date of commencement of CARP, NCLT declares a moratorium prohibiting following actions, in which 2 clauses are important for us. One is there cannot be any institution of suit or continuation of pending suit or proceeding, and including execution of any judgment, decree, or order in any court, tribunal, arbitration panel, or other authority. The wordings are so broad, it may include each and every authority which may be there, right? And when it says court, tribunal, or other authority, a Supreme Court committee may also could have come in this, but we are not getting into that. Second aspect of moratorium clauses, there cannot be any transferring, encumbering, alienating, or disposing of CD by the CD of any of his assets. It says by the CD, but if somebody else is doing it, this clause may not be triggered, but ultimately the assets are getting disturbed. If we read the ILC report, the concept of moratorium was that the company should get a cooling period for like 6 months, so the RP is able to do his activities and find a resolution applicant, revive the company. If the asset base is going to be disturbed within that 6 months, it's going to be very hard to achieve a resolution. So somewhere the moratorium is getting impacted by such attachment. Section 18, clause F, mandates the IRP to take custody and control of assets on which company has ownership right. How do you determine this when there are some provisional attachment under Section 4 of MPID Act, which talks about vesting, but vesting may not necessarily mean transfer of title. And MPID also talks about Section 7 where it gets absolute. Had vesting in Section 4 meant complete transfer of title, there would not be any necessity for Section 7. But again, that's a different discussion altogether. But how do a IRP, as on date of ICD, consider if some attached asset under MPID Act is to be considered in the information memorandum or not? How does he determine whether he has to take custody control of that or not? So that becomes a very important section. Then Section 238, like Surya Narayana sir said, Section 14 of MPID is there as a non-obstante clause. We have a section in Section 238 in IBC as well, which is a later act, which is an act under List 3 of Schedule 7 of the Constitution of India. And it overrides anything which is inconsistent with the provision of IBC. We are not saying conflict. We are not saying IBC is supreme. But the provision of Section 238 says any inconsistencies, then IBC has to prevail. And that is the submission which was being made at all stages, that there is an inconsistency between IBC and MPID Act, because only one of them can take custody and control, either the IRP or RP under IBC or the competent authority under MPID Act. Both persons cannot take custody and control of the same asset. So these were the important provision which we wanted to synergize with the discussion. And again, object of IBC is time-bound manner, maximization of value of asset, and balancing interest of stakeholder. If you look at MPID, it's going to take care of the depositors. In IBC, you have all stakeholders, including depositors. And value of assets can be maximized only when there are assets to protect and preserve and use for the resolution process. If attached asset under section 4 of MPID are not assets, then there is nothing to maximize. Time-bound manner of IBC 180, 270, or 330 days cannot be sanctitized or followed if I have such attachments which are going to stretch for a longer period of time, where as an IP I'm not able to take custody and control.
And importantly, Badri,
Yes,
sorry to interrupt. Importantly, Badri, what is important in section 14 is not only institution of fresh proceedings, but the continuation. See, the institution of suits or continuation of pending suits or proceedings against the corporate debtor. Well, the proceedings could have been initiated under other law prior to the imposition of the moratorium. But it is once the moratorium it is in place, that is the intent, of the lawmakers, that the continuation of the proceedings against the corporate debtor, be any civil proceedings or be it attachment proceedings, should not be continued, is the purport and the intent. And if we read section 14 and 238 together, it is clear in this regard.
Yes, sir. I think, Surya sir, you would like to talk about RCM infra case as well.
Yes.
Yes, sir.
There was one judgment of the Supreme Court in IOB, Union Bank of India, Indian Overseas Bank versus RCM Infrastructure, where a surfacing notice was issued prior to the commencement of the moratorium, and then the sale was announced prior to the moratorium, but sale certificate was issued after the imposition of the moratorium. Now, the Honorable NCLT has said that issuance of the sale certificate, that means you have continued the proceedings after the imposition of the moratorium. Therefore, the issuance of sale certificate is not valid in the eyes of law in view of the provisions contained in section 14 and 238, and has set aside the sale. On an appeal, the Honorable NCLAT has upheld the order passed by the NCLT Hyderabad, and then on an appeal by the Indian Overseas Bank, the Honorable Supreme Court, after dealing with various other case laws on the subject, about the the overriding effect of the SURFACE, etc., has rendered that it is the IBC which would prevail over the SURFACE, and they said that once the moratorium is imposed, then even though the auction has been made and they have set aside the sale. In fact, the other case also is where the IBC's overriding effect has been upheld, not only under this case, but also that there are various other judgments also, like ABG Shipyard, where 238 has prevailed over the provisions of the Customs Act, and then they said that Customs Act should pave way for IBC. Similarly, in Duncan's case, the Honorable Supreme Court has held that the T Act would give way for the IBC. In that case, IBC proceedings were sought to be instituted against a tea company, but the Tea Act says that if any proceeding has to be initiated, either of the insolvency or winding up proceedings, etc., have to be initiated against a company which is into tea plantations and etc., then the prior approval of the central government is required under the Tea Act. But again, dealing with the provisions contained in section 238, the Honorable Court said IBC will override the provisions of T Act. So there are number of judgments where IBC supremacy or the overriding effect of the IBC has been upheld, by the Honorable Supreme Court, be it ABG Shipyard, be it IOB versus RCM, be it Duncan's. Why even an order of High Court, where a High Court has ordered for the auction of the properties of a company during moratorium, that is Anandrao Karoda versus Varsha Fabrics, where the Honorable Orissa High Court has ordered for the sale of assets of the company for the payment of wages of the workers. No, again, it is for the payment of the wages of the workers, which were pending for quite some time. But since the Honorable High Court of Orissa has passed this order during the moratorium, the Honorable Supreme Court said that that cannot be done because they upheld the sanctity. See, they talked about the sanctity of the moratorium. No, that is the preservation of the assets, not only preservation, but also protection of the assets of a corporate debtor during the CARP process. Yes, continue.
Thank you, sir. In fact, sir, just wanted to touch upon the Revenue Recovery Act case also. We had a very interesting judgment in Honorable NCLT Hyderabad, where the NCLT held that IBC overrides Andhra Pradesh Revenue Recovery Act. And there, a very similar instance where prior to CRP, an auction notice was issued under Revenue Recovery Act for selling assets of the company so that payment can be made to the sugarcane farmers. And but Revenue Recovery Act stipulates a 30-day period for payment of the entire money. That 30-day period was not complied by the bidder, and then CRP started. After CRP started, the RP had intimated the collector of the district not to proceed with the sale since CRP is there and he has to take custody of assets. But even then, the collector went on and took the balance money and issued sale certificate. And this was contested by the resolution professional before NCLT, and Honorable NCLT set aside that sale. And again, upholding, the supremacy of IBC in cases of inconsistencies, and holding that, Section 238 will allow IBC to prevail over Revenue Recovery Act. And so this also, I think, was relevant.
And there, in fact, part consideration was paid before the imposition of the moratorium.
Correct.
Yes, the total consideration of about 20 crores, around 10 crores being paid prior to the imposition of the moratorium, that is June 24th was the moratorium that was imposed, and the balance consideration was paid on 2nd November or November 24th. On November 24th, the balance consideration was paid. So it is part consideration paid before moratorium, part consideration paid after the moratorium. NCLT has rendered the sale to be invalid and stating that IBC will override the Revenue Recovery Act.
Yes. Just for a disclaimer, that case is in appeal before Honorable NCLAT.
And there is a status quo that has been ordered.
Status quo has been ordered.
Yes.
So I'll continue with the facts of the case.
Yes. Yeah, I think the audience will be able to appreciate. Then they will be able to appreciate, how the Honorable Supreme Court has dealt with this case and what would be the ramifications or the implications of this case further down the line.
Yes, sir. Yes, sir. Though everybody who reads the judgment will get some idea of what the judgment was, but not everyone will know how it transpired to that status and what were the facts and circumstances in the corporate debtor which were affected by this judgment. So to start with, let me give you a very brief background about NSEL, which is the National Spot Exchange Limited. It was basically an electronic trading platform, an exchange platform, and it used to do a lot of spot contracts. Since everybody or most of the participants will be chartered accountants, they'll be knowing about forward contract and spot contracts. So NSEL was a platform which facilitated spot trading and forward trading. So they brought out a modality called T+2 and T+25 paired contract, right, where T+2 a transaction happens, a buy transaction happens, and simultaneously they enter into a contract where a T+25 forward sell also happens. So this creates a transaction which apparently or was shown that would generate profit for the traders and very good profit for the traders. That was the marketing bait which was put at that point in time. So the issues happened somewhere in 2013. So we are talking almost 13 years back. What has happened? So they started as spot trading. They got a license and then started for forward trading. The settlement period varied from T plus 0 to T plus 36. And this is how it used to work. So just giving an example for very simple understanding of the participants here. The case we are talking about and the issues which arose were due to T plus 2 and T plus 25 contract. Majorly the transactions were into this. Now, a very broad understanding is NSEL used to take money from depositors, right? People like investors who wanted to invest in these trading contracts. And these monies were then given to members of NSEL who are like trading and clearing members of NSEL. So our corporate debtor was also a trading and clearing member of NSEL. These trading and clearing member normally are manufacturers of commodity. They will manufacture sugar, oil seed, pulses, agricultural commodities, things like that, right? So these trading members have the commodity, they manufacture commodity. They are able to put those commodity in a warehouse, which is in custody of NSEL, and NSEL facilitates a paid contract between interested buyer and interested seller. Seller is the trading member and buyer is the investor. So a T plus 2, T plus 25 contract is facilitated through obviously online matching, like how it happens in your stock market as well, where a buyer, suppose A, he wants to buy some sugar, right? He will go and put his transaction into the system that I want so much quantity of sugar. And if the quantity matches with a seller who is also interested in selling that amount of sugar, the transaction is effected. Now, the seller who has the sugar, he has to deposit that into the warehouse of NSEL to show that the quantity exists, right? And when that deposit happens, NSEL takes money from the buyer because the buyer is buying the commodity, he has to pay, right? So NSEL takes money from the buyer, keeps it in his settlement account, in NSEL settlement account. And when the seller has deposited the commodity in the warehouse, that money goes to the seller. Now, after 25 days at T plus 25, the same buyer who had bought the commodity from the seller, he does a sell transaction. He sells the commodity to the seller, and the difference which he makes between this T plus 0 and T plus 25 was made as if it will be a huge profit at around 16 to 24% per annum on annualized return. And that is how the depositors were lured into transacting into the system. I really hope this I could make it as simple as possible because it's actually a large flow of transaction. But the simple concept is the same buyer becomes a seller. A buy transaction and a sell transaction is together executed with different timeline. Buy happens as 0 or 2 and the sell happens at T plus 25. And the difference which exists between the buy and sell is the profit for the investor. Now, many people like you and me, normal citizens, would have got attracted to the scheme when NSEL said, you can invest in this and you'll get 16%, 24%, which is way better than your FD interest. We, as common innocent citizen, get interested. We are greedy also, and greed is never good. And we end up investing money in such schemes. Now, money went to NSEL. From NSEL, it went to the trading cum clearing members. The issue happened when the trading cum clearing members could not repay the money back, because when they have to buy again, they sold once. Now they have to buy again to clear the T plus 25, right? So when they had to buy again, they did not have money because of whatever reasons. They used it in the business, they diverted it somewhere. But when they did not have money, they could not pay NSEL. They defaulted to NSEL. Hence, NSEL also defaulted to depositors. And the fraud, if I may say, happened when it was found out that there was no commodity which was secured in the warehouse. As per the modality, the seller should deposit the commodity in the warehouse so that there is existence of the commodity. But warehouse receipts were being fabricated to show as if commodities existed, and money went back and forth between these people, and the depositors were never paid. If the commodities were actually there, then at least those commodities could have been sold, money could have been recovered, and depositors' money could have been returned. But because there did not exist any commodity or what was promised, hence the default occurred. Now, this is part of actually 63 moons judgment. If you read the judgment, the entire modality step by step as to what happens is explained there, but we don't want to get into the technicalities. So an example is given here how NSEL contracts used to float in the market. So in case you want to get into cash receipts, NSEL will hold out a buy contract, say T+3. We had T+2 and T+25. Here you have T+3 and T+36. A buy contract at T+3 and a sale contract at T+36. And they will say the interest or the yield from this contract will be 16%. Anybody would obviously be interested. NSEL also represented the following, that the traders can trade and log their return. So that means you will have guaranteed return. The traders has to buy in near settlement contract and sell in far settlement contract. So you have to buy near and sell far. Then the price for both the settlement are available. So you have certainty. And exchange provides counterparty guarantee risk. So any issue happens, exchange will indemnify. No basis risk, no link with future contract, right? Then while describing features of the trading opportunity, some more representation made by NSEL at that point in time was the T+2, T+25 contract offers unique trading opportunity to traders. So it was sold as a hot cake to the traders. Traders purchase T+2 contract and consequently, simultaneously sells T+25 contract. The pay-in obligation is on T+2 because when you're buying, you will be giving money to the NSEL, and the payout of the funds will be on T+25. Entire settlement cycle was 35 to 37 days. So in a month, you are able to generate that return. Price difference on annualized interest rate is around 16%, and income arising are treated as business income so that you can set off business expenses as well. So this was the model on which NSEL operated. This was the marketing bait in which a lot of depositors fell. And then what followed on due to this was, because the members of NSEL defaulted in paying back to NSEL, hence NSEL also could not pay back depositors. There was a default of around 5,600 crores. This we are talking about 2013. And this is money of hard earning, tax paying citizens who had become depositors in the scheme, and a fraud or a scam of 5,600 crores was uncovered at that point in time. Pursuant to a default, in July 2013, Mr. Pankaj Saraf had filed a complaint. He has registered an FIR, and this FIR also led into MPID Act. So this was the genesis, we can say, or the root cause of the entire proceedings which we are seeing. The complaint by Mr. Pankaj Saraf lodged as an FIR in IPC and then transferred into MPID Act because the investigation went to Economic Offences Wing, and when it went to them, they lodged MPID Act also in this. That is how MPID Act came into the picture in this case. So around 9 years investigation, 11 charge sheets were filed in this case. The corporator which we handled was a member of NSEL. It was a trading and clearing member, and it also defaulted in certain obligations. Now, August 2013, NSEL declared the corporator as a defaulter as per its bylaws. Like banks have rules for willful defaulter, NSEL had bylaws to declare a corporate debtor or member as a defaulter. They declared the corporate debtor as a defaulter. Many notifications were issued. This we are talking prior to CRP. Many notifications were issued under MPID Act for attachment of corporate debtors property under Section 4, which we are referring to as provisional attachment. And at least large land banks of the companies, including other companies which were also there in this NSEL issue, their properties were also attached. Bank accounts, land, immovable properties, promoter properties, everything was attached under Section 4 of MPID Act. The government of Maharashtra had constituted a designated court to hear the MPID cases to be on a fast track basis, and also instituted a competent authority, which is the deputy collector who sits in Bombay, for being the competent authority under MPID Act. Now, this designated court and competent authority have to work together. The competent authority prepares an affidavit of what assets are there, what objections are received. He puts it before the honorable designated court, and the designated court under Section 7 has the power to make an attachment absolute. So obviously there is a court-driven process even in the MPID Act. Now, while this was going on, NSEL, because of its bylaws, so NSEL license was suspended, the board was overtaken, and now actually it is acting as a facilitator to recover deposits for depositors. So when all this was going on, NSEL, according to its bylaws, initiated arbitration proceedings against the defaulting trading cum clearing members, like our corporate debtor. So they initiated multiple arbitration proceedings against multiple defaulters, and they got multiple awards as well. arbitration awards as well. And obviously, these awards have to be executed. So they filed execution petitions all over India across various courts. Now it was becoming very burdensome to administer these awards, these executions, because it was spread across India. And so NSEL went to Honorable Supreme Court, filed a writ petition, which is 995 by 2019, in which you have this recent judgment as well. So this writ petition was filed seeking consolidation of arbitration enforcement. And in between these, the 63 Moons Technology case came, where Honorable Apex Court held MPID to be constitutional, and it also said that NSEL is a financial establishment. An interesting fact here is it's not only NSEL which was a financial establishment. Even if you see the notifications issued by Maharashtra state government, the defaulters were also considered as financial establishment because indirectly they have taken the deposit from the investors. So I'll request Surya Narayana sir to go about the Constitution of Supreme Court Committee and the consequent appeal.
Yes. So for the purpose of overseeing the execution of these awards, this writ petition was filed, and then the Supreme Court has, in exercise of its powers under Article 142 of the Constitution, has constituted this high-powered Supreme Court committee. So all the proceedings, all the decrees, orders, arbitral awards, etc., have been transferred to the Supreme Court committee for speedy execution. Then now the CIRP has been initiated now in this case against the corporate debtor, that is NCS Sugars, in June 2022. It was in June 2022 that the CIRP proceedings have been initiated. Now, NSEL has also filed its claim as financial creditor before the RP, and then it was admitted as a secured financial creditor. Then, as counsel for RP, I have appeared before the Supreme Court committee, and the Supreme Court committee, vide its order dated 8th January 2024, has decided, because we have taken an objection before the Supreme Court committee, stating that our case was that these attachments are made prior to the commencement of the CIRP. The attachments were not made absolute as on the date of commencement of the CIRP, and that once moratorium is imposed and when the RP is supposed to take control and custody of the assets under Section 18F, then he would have all the power in view of the Section 238. And we also said that the term vesting used in Section 4 of the MPID Act would not amount to the transfer of title, because Section 4 has to be read with Section 7. And these were the submissions that were made. However, the Honorable Supreme Court, the committee has decided the question of law on IBC versus MPID. And after dealing very elaborately, of course, it was a very, very elaborate order referring to various judgments on the interplay between the state law and the central law, state list, union list, the plenary powers, Section 246, Article 246, Article 254, etc. have all been discussed. And then it finally said that the MPID Act would override the IBC, and therefore the properties attached of the various corporate debtors, not only this corporate debtor, there are also other corporate debtors who were, undergoing the CIRP. So they said that these properties and some of the corporate debtors were facing the attachments under the PMLA. So, and in some of the corporates, the bankers, who have lent money, there is a security interest created in favor of the banks and financial institutions. So uh, this led to this order of 8/1/2024 by the Supreme Court committee. The committee was headed by an ex-chief justice of the Bombay High Court. It was a single judge committee. So that committee has passed this order on 8/1/2024, rendering that MPID would prevail over IBC. So then this led to filing of an appeal by way of an IA. In the an interlocutory application has been filed in the Supreme Court, because the Supreme Court, at the time of passing the order on 4th May 2022, they also gave a liberty, stating that if any person has any objections or aggrieved in any manner of by the order passed by the Supreme Court committee, that liberty was given to approach the Supreme Court. So therefore, the RP of the corporate debtor, aggrieved by the order passed by the Supreme Court committee on 8th January 2024, filed this application before the Supreme Court. Now, the Supreme Court, while the order dated 2nd April 2024, framed two questions. Now, the next slide. Now, the first question was concerning the secured creditors, who said that SURFACE would prevail. So the question is whether the secured creditors would have priority of interest over the assets attached under the provisions of Prevention of Money Laundering Act and Maharashtra Protection of Investors and Depositors Act 1999 by virtue of the provisions of SURFACE Act 2002 and RDB Act 1993, in view of the order dated 10/8/2023 passed by the committee. And then whether the properties of the judgment debtors and garnishes attached under the provisions of the MPID Act 1999 would be available for the execution of the decrees against the judgment debtors in view of the provisions of moratorium under section 14 of the IBC 2016. This is in view of the order passed on 8/1/2024. So the Supreme Court has framed these two primary questions, two very important questions. One is regarding the SURFACE, and then the other is MPID versus the IBC.
Surya sir, sorry to interrupt. Just wanted to add on one point here.
Yeah.
In the Supreme Court committee order, which you explained in 8 January order, interesting aspect which was touched upon was the concept of civil forfeiture.
Correct.
The Supreme Court committee held that the action under Section 4 of MPID Act is like a concept of civil forfeiture, and once an asset is attached under Section 4, that becomes property of the state and property of the competent authority. It vests in him, and the corporate debtor has no rights over such property. So the concept of civil forfeiture from Western literature, judicial precedents also played a large role in the judgment came to be. And sir, would you like
they referred even to the provisions of the MPID Act while dealing with it, saying that it amounts to a civil forfeiture. Section 4, Section 5 have been referred to.
In fact, sir, we should give it to the committee also that the committee in its judgment did say that any attachment prior to CARP will obviously vest in the competent authority, but for anything after the commencement of CRP, suitable claim form has to be filed by the decree holder, which was NSEL in this case. So they also appreciated, the Supreme Court committee also appreciated the concept of CRP moratorium to the extent that they said after commencement of CRP, any claim is there or any attachment has to be done will be by way of claim before the resolution professional and will be treated accordingly.
Yes, that is the attachment after the commencement
of CRP.
After
so they
the commencement,
understand that moratorium was there and there was an effect of the moratorium, but they held that Section 4 attachment, if it has happened prior to CRP.
Correct. That is what I'm coming to. See, but unfortunately, whether rightly or wrongly, they said that any attachment under Section 4 of the MPID Act prior to the commencement of the CARP would be absolute, as if it is absolute, and it will, that it cannot give way to IBC.
Yes.
Right.
Yes.
And now that is what was contested, especially in view of Section 4, read with the provisions contained in Section 7.
Also, for the interest of participants, I just wanted to highlight a bit more here that there were cases where secured creditors existed in a corporate debtor who had existing security interest, and there was PMLA attachment, there was MPID attachments there. So the secured creditors also were battling the issue before the apex court, saying
Correct. That's
we have
what
the
I said.
existing security interest,
Yeah.
and how come an attached asset is getting priority over the security interest which was on our name? And in fact, there are previous judgments also which upholds that if there is a security interest created, some state enactment cannot transgress that security interest. But now it has been held in another way. So here the bankers were also fighting, and the corporate debtor RPs were also fighting, and
Correct.
even RPs of personal guarantors were also there.
Correct.
Because when SEC passed its order, it considered the moratorium as Section 14 as well as Section 96, which was for personal guarantor.
Correct.
So that's why it became very crucial. And these two questions were framed. Surya sir, would you like me to project the judgment and you want to take them through the floor?
Yes.
That
Yes.
will be better. Rather than
Yes.
reading the conclusion, let me project
Correct.
the judgment. I have
Correct.
some highlighted paragraph
Yes, please.
that will be very helpful for the.
Yes. That's what I want.
Please let me know once it's visible, sir.
Yes, we can see that.
Sir, let me take you to the paragraph. I'll just broadly run through the judgment for the participants. So
Yeah.
this is the judgment dated 15 May 2025, National Spot Exchange versus Union of India. This is the matter we are discussing about. So first, a very broad overview of the NSEL contract modalities, what transaction happens, that was all given. And then they also talk about the scam. It's 5,600 crore failure against 24 defaulted members. And provisions of PMLA Act was also enforced here. SFI also did an investigation. So a lot of things have happened here. Then 4th May 2022, like Surya sir said, is the order where Supreme Court committee was constituted. The judgment speaks about all that in detail. And here it also said the Supreme Court committee was given powers of a civil court for execution of all decrees and arbitral awards. So as we understand, the contours of the Supreme Court committee was execution of awards. And as everybody is aware, Section 14 prohibits enforcement of even awards. Then the judgment talks about 63 Moon Technology judgment, where NSEL has been held as financial establishment. Then it goes about talking about MPID Act and what proceedings happened before Honorable Supreme Court Committee, how the 10th August 2023 and 8th January 2024, these two orders were passed by Honorable Supreme Court Committee. We as a corporate debtor were speaking about the 8th January 2024 order. The surface and other issues are covered in 10th 8 and partly by 8th January order. Then the court talks about the scope of Article 142 because the SEC was instituted under Article 142, and the court depicts that obviously the Supreme Court will not use power under 142 to just create anything. It will have relevance to other existing statutory provisions, and it will not create an obstacle to other provisions. So in para 14, they are saying that with regard to scope and ambit of Article 142, if the facts of the case are appreciated, particularly with regard to circumstances under which this court had bought its power by order dated 4th May. So the Supreme Court is saying that because of the facts of the case, because of the depositor's interest, the Supreme Court had instituted the Supreme Court Committee. Surya sir, can you take it forward from here? I'll just show you the highlighted parts of it.
Yes.
Yes, sir, here.
So now the case is clear to us. Now here is a case where there were attachments that were made under the MPID Act prior to the commencement of the moratorium, and moratorium was imposed after the commencement, after the attachments were made, but the attachments were not made absolute, and some of the assets of the corporate debtor were being sold. In fact, one important aspect which I think which I have not earlier mentioned is that even the properties, the immovable properties of the corporate debtor were being sold by the competent authority during the moratorium. Now, so it is in this background that we are, studying this case, that as to what will be the effect of this case in future, say, insolvency proceedings, and what is this case all about. So it is a state enactment under which the attachment is made, and then the IBC comes into force, and then moratorium is imposed. During moratorium, assets are sold. Now the Supreme Court committee says that the assets would be available for the execution. Moratorium, no problem, does not matter. They are available. That is what the Supreme Court committee has said. And against this, we have gone to the Supreme Court. And then this is what the Supreme Court has said after framing its question on the interplay between the MPID and the IBC. So it says that the court had passed the order on 4/5/2022. That is the first order passed by the Supreme Court for the Constitution, under Article 142, with the objective of attaining the holistic solution for the speedy recovery of the outstanding amounts. Now, this court also has constituted a committee. That committee has been conferred with all the powers of civil court for the speedy execution of the decrees and the arbitral awards, and further directed the SC committee shall be entitled to sell the properties. Right. Now,
notwithstanding attachment under PMLA. So
yes, notwithstanding
broad powers.
Again, to sell the properties of the judgment debtors, notwithstanding the judgment, the attachment thereof by the enforcement directorate under the PMLA and or by the state of Maharashtra under the MPID Act, to the extent of the recovery of the amount of the decree. See, the Supreme Court was solely focused, I would say, on the recovery, sell, attach, sell, recover, and then pay it, execute. That is what was the focus. Then again, then the Supreme Court said that it is true that while passing the order, on 4/5/2022, this court probably would not have contemplated the possibility of the legal issues. But again, the conflict of the provisions contained in the SURFACE, RDB Act, PMLA, MPID, which were subsequently raised before the SC committee. So this is what the Supreme Court said, that we do therefore find substance in the submissions made by the learned counsel appearing for the applicant secured creditors, that while exercising the powers under Article 142, the express provisions in the other relevant statutes should not be ignored, particularly when the exercise of powers under Article 142 would directly be in conflict with what has been express provisions in such statutes. It is also true that when this court passed the order on 4/5/2022, it had the potentiality of being in conflict with other statutes like SURFACE, RDB Act, IBC, etc. So here, the Supreme Court very correctly, it says that, while we are exercising our powers under 142, we should also bear in mind the provisions of the other enactments, and our order passed under Article 142 should not amount to transgressing the provisions contained in those enactments. So the Supreme Court, while passing this order, was very much conscious of its powers under Article 142 and that it cannot entrench upon the provisions contained in the other enactments. Also, we cannot be oblivious to the fact that such existence of power under Article 142 was for the speedy recovery of monies lost by the defaulters and investors, and for doing the complete justice to the aggrieved traders. So this is what the Supreme Court was quite conscious, of its powers, and then, rendered this judgment. But however, in doing so, what has happened?
Sir, I'll because we'll be short on time as well. So let me take you through the relevant paras. But before that, so the structure of judgment is they talk about Article 142. Honorable Supreme Court expresses what Surya sir said and then goes on to deal with question by question. The first question was whether the secured creditors would have priority of interest over assets attached under PMLA, MPID, and SURFACE and RDB. So what issue happened here was there were multiple attachments. There were attachment under PMLA, there were attachment under MPID, and you had security interest under SURFACE Act and RDB Act. So different stakeholders face different kind of issues. So the first question was whether under SURFACE and RDB, secured creditor right on the asset will have priority over the attached asset under PMLA and MPID Act. So here the judgment goes through the objects of each of the Act, RDB Act, PMLA Act, SURFACE Act, and MPID Act, and the provisions of the same, and then gives a genesis of what transpires in it. So all these are like judgments. So in MPID Act also they talk about Section 14 overriding provision. Then they speak about Article 246, which Surya sir very eloquently described. Article 246 gives us the federal structure, how the powers are distributed between the state and the center. So you have first list 1, then list 3, and then list 2. That is how Article 246 is envisaged. And then it also talks about Article 254, which brings in the doctrine of repugnancy when two laws, say state and central, are within list 3 and there is a conflict. Then doctrine of repugnancy, a repugnancy is there, then doctrine of repugnancy comes in and the central law prevails. But because in our case, the IBC is in list 3 and the MPID Act is in list 2, the court went ahead and said that Article 254 will not be applicable here because they are not forming part of the same list. Surya sir,
I think, Badri, maybe we have to just take the audience through once the 246. I mean, if you go up.
Yeah, sure, sir.
I think if we can.
Yes.
So, because this is the basis on which the judgment has been rendered, right? This is the basis, right? So, subject matter of laws made by Parliament and state legislatures. Now, list 1, the Parliament will have the exclusive power. That is the union list. Now, coming to the list 3, that is the concurrent list. 246(2) deals with list 3. It says that notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also have power to make laws with respect to any of the matters enumerated in the list 3 of the 7th schedule. I think here in this judgment, they have, I think, missed one important comma in 2, in sub-article 2 of Article 246, because sub-article 2 says, notwithstanding anything in clause 3, Parliament, comma, there's a comma after Parliament. Parliament, comma, and comma, subject to clause 1, comma, the legislature of any state also, comma. So it is a Parliament and also the state legislature which will have the powers, but it is all subject to clause 3. Have power to make laws with respect to any of the matters enumerated in list 3 of the 7th schedule. That is, in the concurrent list, both the state will have the power and the state and Parliament will have the power, but of course subject to
notwithstanding.
clause 3.
This is notwithstanding clause 3. So yes, the wording is such that list 1 obviously.
Yes, and subject to clause 1.
Yeah, subject to clause 1. So
subject to clause 1. That means you cannot touch union list.
Yes.
But subject to clause 3, both Parliament and state will have the power. Now see clause 3, sub-article 3 of. Subject to clause 1 and 2, the legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule. That means a subject which is not falling under the union list and which is also not there in the concurrent list, the state will have the power. Subject to clause 1 and 2, legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2. Now the parliament has power to, now it says parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state list. That is, notwithstanding that such matter is a matter enumerated in the state list. So Parliament will have that power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state list. Now, this is what, say, Article 246 says. Now, they have also discussed. So now here, the judgment discusses about the threefold distribution of legislative power between the union and the states made in the three lists in the 7th schedule. And then it says that Article 246 exhibits the principle of federal supremacy, that in case of inevitable conflict between the union and state powers, the union power as enumerated in list 1 shall prevail over the state list. Okay, state power as enumerated in the list 2 and list 3, and in case of overlapping between the two, list 2 and list 3, the latter shall prevail. In fact, the union list will prevail.
No, in fact, list 2, list 3, the concurrent list, the latter is the concurrent list that will
concurrent
prevail.
List that will prevail. Yeah.
So this was also built in the judgment. But again, as we say, MPID is a state list enactment and IBC is a central list.
Correct.
And
so
then
they discussed various other judgments.
Yes. So it has reference to host pharmaceutical case, which was referred in innovative judgment as well, where the judgment speaks about Article 254 and the doctrine of repugnancy. In innovative, as we all know, Maharashtra Act had to give way
Maharashtra Relief Undertakings
Act had to give way to IBC, and that was one of the first judgments from Honorable Apex Court.
Honorable Judge Sri Nariman has rendered that judgment,
and somewhere that set the founding stone for IBC's evolution and the strong base which IBC needed for its functioning. Then this judgment goes on to talk about different provisions of SARFAESI Act, RDB Act, and PMLA. It also talks about how MPD's constitutional validity was upheld in KK Bhaskaran case, 63 Moon Technology case. Right, and then it says that in KK Bhaskaran case, it was held that Tamil Nadu Act, Interest of Depositors Act, was in pith and substance related to state list. So here they upheld the constitutionality of the Tamil Nadu Act, and they also noticed that the RBI Act, Banking Regulation Act, or Companies Act did not occupy the field which the impugned Tamil Nadu Protection of Interest of Depositors had at that time. But later things may have changed. Just like here, MPID came in 1999, IBC came in 2016. So at the point when MPID came, maybe IBC or anything did not occupy that field. But once IBC has come, obviously there is some inconsistency. The court goes on to say that there remains no shadow of doubt that state of Maharashtra was within legislative competence to enact MPID Act, the subject matter of which was in pith and substance of entries in state list. So the Honorable Court is holding that this is a valid enactment and the state was validly allowed to do. Similarly, they talk about PMLA and SARFAESI's constitutionality, that it is upheld as constitution. Then it is held. This is question 1 we are discussing. It is held, however, merely because SARFAESI and RDB, which are enacted in respect of subject matter falling in list 1 and having been enacted by Parliament, they could not be permitted to override MPID Act, which is validly enacted for matter falling under list 2 state list. If such interpretation is permitted, it would amount to denuding the state of its legislative power to enact and enforce legislation which is within the exclusive domain of the state, and it would offend the very principle of federal structure in Article 246, held to be part of basic structure of Constitution of India, which was again questioned on the Bharti case. The basic structure cannot be modified. So here, Honorable Court is saying that Union List Acts cannot override a state enactment which the state was validly, allowed to enact. Then they go on to discuss that in view of the positions settled by Constitution Bench, it is held that the doctrine of pith and substance of the state and central legislation, SARFAESI, RDB, cannot be permitted to prevail over state legislation. So clearly, they said that security interest of secured creditors will not have priority over the attached asset under MPID Act. They also go on to say that since all these acts have separate field of operation, provision of SARFAESI and RDB cannot be permitted to override MPID, which is validly enacted state legislation. The respective legislative powers of the union and state are traceable in Article 245 to 254. Status quo Constitution is federal in structure and independent in its exercise of legislative and executive power. If provisions of SARFAESI RDB are permitted to override, then legislative powers would be denuded. They are saying that then there will be no point of giving states any power to make legislation. Then they also go on to talk about predominance of legislation. Then they say that they talk about that in this case at hand, SARFAESI Act and RDB having been enacted by Parliament, subject matter falling in List 1 and MPID Act in List 2, the latter, which is MPID Act, would prevail in the state of Maharashtra in respect of specific subject matter for which the said act was enacted under 246(3). So this is how they have gone ahead and dealt with for all SARFAESI and RDB both in the same view. Now coming on to the next question of MPID Act and the IBC. Surya sir, would you like to?
Yes.
Yes.
I mean, we can.
Maybe
Question here is, this takes us
we'll
to the second question, whether the properties of judgment debtors and garnishes attached under the MPID Act would be available for the execution of decrees against the judgment debtors in view of the provisions of moratorium under section 14 of the IBC 2016. So we are talking about the interplay between the MPID and section 14 moratorium under the IBC here. So now come to the relevant para. They have discussed all this. Now, this is an aspect which was argued and which was also dealt here, that if the moratorium is imposed subsequent to the date of the attachment under the MPID Act, the contention has been that there is no retrospective operation of section 14 pertaining to the moratorium. Such attached properties under the MPID Act would no longer be available as a properties of the corporate debtor to be considered for the purpose of the resolution plan under the IBC. So the argument is that since the attachment is under the MPID Act is prior to the moratorium does not have any that if in 2021 or 22 the moratorium is imposed and the attachment has taken place, say in 2016 or 2017, then the moratorium will not have the retrospective effect, is the argument. But what is, in my humble view, is missed out is that the continuation of the proceedings. Now, moratorium under section 14, while we are saying that it does not have the retrospective effect, no, you cannot continue the proceedings. They are of civil forfeiture, right? The attachment. So these proceedings which are, say, civil in nature cannot be continued once the moratorium is imposed. So what does it say? The attached properties would vest in the competent authority appointed by the state government, and therefore such properties would no longer be the properties of the judgment debtor or the garnishee, and therefore would be outside the scope of the operation and application of IBC. Yes. Next. So here
they go about.
They say now the object of the, what is the objective? What is the purpose of MPID? MPID was enacted in public interest to curb the unscrupulous activities of the financial establishments. It is for the protection of the depositors, who had defaulted to return. So this has been, of course, discussed in 63 Moon Technologies. So as discussed while answering the first question, it was held that the MPID Act has been validly enacted, constitutional validity has been upheld, and that it is falling under the list 2. But IBC has been enacted to consolidate and amend the laws retaining to the reorganization of the insolvency resolution of the corporate debtors. So the subject matter of IBC being bankruptcy and insolvency is relatable to entry 9 list 3 concurrent list. The MPID Act having been enacted for the matters relatable to the entries 1, 30 and 32 in list 2 state list, and the IBC having been enacted for the matters relatable to entry 9 so and so, the provisions of Article 254 would not be attracted. as per the settled legal position discussed earlier, the issue of repugnancy or conflict as contemplated in Article 254 would arise only when the state legislation and the central legislation both are relatable to the entries contained in the list 3 concurrent list. So therefore, again, innovative industries has been discussed, and they say that in the instant case, there is no overlap or inconsistency between the provisions contained in IBC and MPID Act. As such, Section 14 IBC has the connotation which is very much different from Section 4 of MPID Act. The proceedings under the IBC arise out of the debtor-creditor relationships of the parties. As per Section 14 of IBC, which pertains to the moratorium, a declaration has to be made to an order by the adjudicating authority prohibiting the acts mentioned therein. Therefore, Section 14 of IBC is consequent upon the order passed by the adjudicating authority declaring moratorium. However, so this is what they say that it has to be admitted, declaration by the adjudicating authority. However, so far as the attachment of the properties under Section 4, the MPID Act is concerned, it is beyond the realm of the corporate of the debtor-creditor relationship as contemplated in IBC on the publication of the order of attachment of properties by the government to protect the interests of the financial establishment. Such properties and assets of the financial establishment and the persons mentioned in subsection 1 of Section 4 would forthwith vest in the competent authority appointed by the government pending further orders from the designated court. So, see, here they say that there is no conflict, there is no overlapping. But in my humble submission is that, my humble view otherwise is that once the RP is appointed and once Section 14 says that no proceedings can continue, and especially the duties imposed upon the corporate debtor says upon the RP, Section 17, Section 18, Section 25, Section 23, where he is required to keep it as a going concern. Now, all these sections read together, impose a duty upon the RP to take control, custody, protect the assets of the corporate debtor. An attachment which has not become absolute and which has not been adjudicated finally will not or should not, disturb the moratorium. So at para 50, they say conjoint reading of Section 457 of the MPID Act makes it clear, though Section 4.2 states about the attached properties being vested in the competent authority appointed by the government, such vesting would be subject to the order passed by the designated court. We therefore see no inconsistencies between the provisions contained in the MPID Act and the IBC. So this is where, I have my views where, as earlier I said, the Section 4 subsection 2 vesting under the MPID Act, when it is not absolute and when it is subject to the orders to be passed by the competent court under Section 7, then when in the meantime, in between Section 4 and 7, when the moratorium is imposed, I think that is where there will be a conflict. That is where there will be some inconsistency. That is where, the overriding effect of Section 238 should be considered. So 51 says, in the absence of any inconsistency, having brought on record between the provisions contained in the MPID Act and in the IBC Section 238 of IBC, which gives overriding effect to the IBC over the other acts for the time being in force, cannot be said to have been attracted. In view of the matter, it is held that the properties of the judgment debtors and garnishes attached under the provisions of the MPID Act would be available for the execution of the decrees against the judgment debtor by the SC committee, despite the provisions of moratorium under Section 14 of the IBC. So for the risk of repetition, again I am repeating, to say that as said in para 51, that there is no inconsistency and that there is no, overlapping between the provisions of IBC and MPID. Definitely, the provisions of MPID Section 4, Section 7 are inconsistent with the provisions contained in Section 14, Section 17, Section 18, Section 25, Section 2, of course, 238 is overriding of the whole. If the corporate debtor is stripped of its assets, or it is said that the no assets are available because they are attached, what are we resolving here? What will the RP say in his information memorandum, or what will be there, for a plan proponent, to propose for any resolution, under a plan for the resolution of the corporate data. Yes.
I just wanted to add on here for the participants.
Yeah.
So, moratorium also has provisions where something can be excluded, just like we now have for that aircraft lease engines case as well, where foreign aircrafts were stuck. So,
absolutely, the power companies' judgments.
Yes. So, if at all the legislation wanted to exclude something, it would have definitely added in saying that MPD attached assets or companies under MPD will fall out of moratorium. When there is nothing specified by legislator, uh, these kind of judgments may also create some uncertainty for the RPs to function, also for the PRAs who want to come and buy the asset.
And also, Badri, I think quickly, since we have discussed only one case till now, I think quickly, what are the ramifications? I think what we should, the participants would like to understand. Okay, this is history. Okay, now this has happened. Now, what is this judgment's impact on the future insolvency resolutions? Now, the future will be that if there is any state enactment which is listed under the state list and under which a state government can exercise the powers of attachment, sale, forfeiture, foreclosure, etc., then the such act will prevail over IBC. Be it any state enactment. So supposing some proceedings are taken out under a state enactment, then the IBC will have to give way to the state enactment by virtue of the judgment if that enactment under which the state government is exercising the power falls, that enactment falls under the state list. So every state has, a number of legislations to protect, the various sections of the public, be it depositors, be it farmers, be it weavers. There can be different class of people, of the public, whom the state government would intend to protect in its state. And if that enactment is made in the state list, and if any such powers are exercised by a state government by virtue of notification under that enactment, then as per this judgment, the IBC will be toothless before the such enactment.
Just from
so that is what is it. That is what is the ramification, the implication of this judgment.
From a practitioner's viewpoint as well, sir, when we step in as an insolvency professional and undertake our duties as IRP and RP, what all problems?
I think you should increase the font size, Badri.
No, this is the judgment, sir. You've already.
Okay. Right.
This is just the judgment.
Yeah. Okay.
Just on the ramifications of MPID versus IBC, as an insolvency professional, what can happen is once you are getting into the office as an IRP, you should first find out what attachments are there and under which enactments they are there. And as on date, what is the applicable legal framework and what is the status of such attachments? And then only proceed to, prepare your information memorandum, because a false or misrepresentative information memorandum can be a ground for even withdrawal of resolution plan. There have been orders at NCLT and CLAT level where a wrong information memorandum was allowed as a ground to withdraw resolution plan. Although in EBIC Supreme Court judgment, modification withdrawal is not allowed, but when the information memorandum itself was given wrong by the IP, withdrawal has been allowed. Second point is, we have to value the corporate debtor. If the main assets are land or plant of the corporate debtor and they are attached, then you're not going to get a proper valuation, and probably you will not be able to achieve a proper resolution. So you have to check the stage of attachment, right? Like sir said, we have different enactments which have different provisions for attachment. In MPID, we felt and we still have a view that section 4 is made absolute only under section 7 by a court, right? And section 4 by itself is not absolute, but other enactments may have different wordings, and you have to check if IBC as per existing precedents are having prevailing enactment over the other enactments. If yes, then you have to take steps to write to those collector, to those authorities, to ensure that moratorium is conveyed to them, to ensure that they don't take any action. And if at all you apprehend some action is going to be taken, you have to proceed and take action and take an IA before Honorable NCLT, because Section 60 subsection 5 gives a wide jurisdiction to Honorable NCLT to entertain issue, because it is an asset which RP has to take custody, and thus becomes a question of law or a priority under insolvency, arising out of insolvency. If insolvency had not commenced, this question would not have come. Because insolvency came and RP has to take custody, this question is coming. So you can very well file an IA before Honorable NCLT also. So first step is to assess attachment. Second is to take steps to protect and preserve your asset. Third is to also consider filing necessary objection before competent forums, not only NCLT. If case is going before MPID or PMLA, file before competent forums also, so that also serves as an additional ground that RP has done his duties. Fourth will be probably the toughest: how to value this asset and how to project it to a PRA to sell this asset. That certainty only will come with a court order, or if a resolution applicant finds strength in your conduct as an RP, how you have handled the case in the attachment, in the framework of IBC over any other enactment, and what stage the attachment is. Then such PRAs may very well like to take that risk, because that gives them a leveraging point. So all these things coupled with Section 32A, which has been upheld by Honorable Supreme Court, where you are getting everything on a clean slate if you have bought the asset and change in management has happened, these things can definitely add value. So these are certain things as a practitioner we have to keep in mind, and obviously we have to take our precautions in keeping things documented, understanding exact survey number of the attached land, because there are cases where there are simply acres mentioned in notification that 40 acres are attached, and you don't have specific survey numbers. So you will never know when the authorities come and sell some land beneath the plant, and they say that this is sold, then that destructs the entire value of the corporate debtor. So these are certain things as a practitioner probably you should keep in mind, and we will have to see how this case goes forward, how other ramifications come from this. But we hope that we could explain a bit about the circumstances in which this case arose, and how this judgment will have prevailing effect. Now, Surya sir, if you would like to take the next case, we should not leave that out completely as well. Although we should do a separate session on the Competition Act.
Yeah, I think that would, in fact, do we have time? I mean,
Sir, we can take 10 minutes, Sarika ma'am, if that's okay.
Yeah, we can take 10 minutes.
10 minutes. We don't want to leave this.
Our Vice Chairman sir is also joining, Rajesh Sharma sir. So within 10 minutes, we have to wind up actually.
We can.
Yeah.
Okay. Quickly, Badri, can you share the
Yes, I'm sharing. Please let me know if it's visible, sir.
As of now, no. Yeah, no. Not this one. Go to independent sugar. Next slides. Few more slides. Are you moving the slides?
Yes. Are you able to see now?
No, I am still seeing NSEL.
Now?
come to Independent Sugar Corporation. Yes.
Okay.
So here is a case where the corporate insolvency resolution process was initiated against National Glass and Industries Limited. Now, this is the corporate debtor, which is one of the largest glass manufacturers. There were two resolution applicants who have participated. One is the AGI Green Pack. This is again a largest glass player. So the resolution plan was approved by the COC with 90% vote. And then the Independent Sugar Corporation Limited also, has participated, and it has challenged the approval, citing lack of CCI clearance, Competition Commission of India approval. As all the learned participants are aware that under Section 5 of the Competition Act, if any amalgamation, merger, acquisition, or takeover results in crossing the threshold limits specified in Section 5, either on the basis of the assets or on the turnover, whether in India or outside India, then a notice will have to be issued to the Competition Commission of India. And upon receipt of such notice, the Competition Commission of India under Section 6, then it will conduct an inquiry under Section 20 of the Competition Act, and then it will deal with. Then there is a procedure of inquiry, that will be conducted under Section 29, and under Section 31, the orders are passed. So the issue is whether when the threshold limit is crossed, the competition notice has to be given, and the approval of the Competition Commission of India is mandatory. So now the legal issue that is here, what happened is, in the resolution plan that has been submitted by Greenpack, the COC has approved the resolution plan subject to obtaining the CCI approval. So the question that has arisen in this, now there were two resolution applicants. Greenpack has obtained, submitted its plan, approved by 98% vote by the COC, and then they said that after the COC approval, go and obtain the CCI approval, Competition Commission of India approval. Now, the other resolution applicant, which has received 88% vote, has already obtained the Competition Commission of India approval. Now, kindly bear this in mind, that CCI approval was obtained by the Independent Sugar Corporation, but its plan has been rejected. So, Independent Sugar Corporation has, finally the matter has been taken to the Supreme Court. So, the issue before the Supreme Court was that, in fact, both the NCLAT and the NCLT and NCLAT have held that, that NCLAT has held that the proviso, under Section 31, subsection 4 is directory, not mandatory. Now, just if I may read Section 31. Now, Section 31, subsection 4, it says that the resolution applicant shall, pursuant to the resolution plan approved under subsection 1, obtain the necessary approval required under any law for the time being in force within a period of 1 year from the date of approval of the resolution plan. That is what subsection 4 says. Now, there is a proviso under that. That proviso says that provided that where the resolution plan contains a provision for combination as referred to in Section 5 of the Competition Act 2002, the resolution applicant shall obtain the approval of the Competition Commission of India under that act prior to such resolution plan, approval of such resolution plan by the COC. So the proviso very clearly says that prior to obtaining of the approval, first the approval by the CCI should be obtained, and then the COC should approve the plan. This is what the proviso says. Now, this proviso was held to be directory by the Honorable NCLAT. Now, on an appeal, this is what are the contentions here? The contentions of the appellant before the Supreme Court is that approval by COC without CCI violates section 31, the proviso to section 31(4), RP has in fact said that this condition has been relaxed and then they can obtain subsequently. He has sent a mail. Plan is conditional and unimplementable without prior CCI approval. In EBIC's judgment, we saw that Supreme Court said that plan should not be conditional. Now here, the plan of the successful resolution applicant, SRA, that is Green Pack, it is conditional upon the plan obtaining the approval from the CCI. And then so the argument was that there should be a literal interpretation when the statute is very clear, when the words employed in the statute are very unambiguous, clear, straight, and capable of being understood in their plain form, then literal implementation is a must. So the SRA's argument was that it is directory. The proviso is directory, not mandatory, which the NCLAT also said. And literal interpretation would only delay the CIRP process, defeating the IBC objectives, and cited absence of any statutory penalty for non-compliance. There is no statutory penalty, and claimed that there is this is the drafters say error in the legislative drafting, so it should not be taken very seriously. So emphasize the need for harmonious construction with Competition Act. So the Supreme Court said that literal interpretation is a must when the words are clear. CCI approval must be obtained prior to the COC approval. When the proviso itself is very clear, CCI approval must be obtained prior to the COC approval. Courts cannot rewrite or dilute statutory language to accommodate procedural convenience. Just because one says that this would lead to delays, CIRP is a time-bound process, therefore this would delay. So first approve the plan by the COC. I have to complete the process by 270 or 330 days. Therefore, the approval CCI can be held subsequently. Therefore, it is directory. All this was not accepted. And then the Supreme Court has reaffirmed. It very clearly said that no, there should be a strict compliance, of course, within the statutory timelines. And then it said that protects the protects the integrity of CIRP, prevents backdoor conditional approvals, and strengthens the interface between IBC and the Competition Act. And then therefore the Supreme Court reaffirmed that legislative clarity must be respected. The word prior in 31(4) of IBC cannot be diluted through interpretation, administrative convenience, or assumed legislative error. So finally, what it says is that the approval is a must. Now, what is its impact? Now, this has been done. What is its impact? Its impact is that it will be very difficult. Of course, there are strict timelines even under the Competition Act, under Section 29. There are timelines that are given. I'm not dealing with that because of the paucity of time. Then otherwise, I would have dealt with what are the timelines, that are specified. But there is one deeming approval provision under the Competition Act. If the Competition Commission does not pass any order of approving or rejecting the combination, earlier it used to be 210 days. Now, by virtue of the Amendment Act passed in 2023, effect from September 2024, now it is 150 days. So if the Competition Commission does not approve, then it is pass any order, then it is a deemed approval. So what is the point of time at which the applicant should submit his application to the CCI will be a question. What is the point of time? At the time of expression of interest, or once he is declared as the eligible PRAs, at that point of time? Well, I think one should read Section 6 of the Competition Act.
Just to add a practitioner's perspective very quickly.
Yeah.
Competition Act is definitely something has to be taken seriously, and we have to respect Competition Act, because if a stressed asset is bought by someone and then that status is used to
Let me
abuse of
absolutely,
dominance position or
absolutely,
adverse
absolutely.
appreciable effect on competition,
Oh
or
yes, oh
combination
yes,
is being distressed, so
yes.
that will create a severe deep-rooted economic depravity in the system itself. So we have to obviously tackle that while we are coordinating with IBC. But
Absolutely.
also, yes, sir, but we also have to look at regulatory efficiencies, how it has to be improved, because we get 180 days to do a CRP and 150 days, I think it is amended timeline for Competition Act. Competition
So
Commission.
if the competition commission does not pass any
Correct, sir.
order,
Correct, sir.
now
That leaves me
kindly,
30 days.
Badri, what I'm saying here is that what you have to appreciate is that the Competition Act would override the provisions of the IBC. In the context that if you see the objectives of the both. Now, if you see the preamble of the Competition Act, no, the Competition Act is, it
Sir,
deals
we are
with.
running short of time. Sorry. Like,
No,
Yeah.
thanks a lot, ma'am. I
So,
think these two.
yeah. So to conclude, the Competition Commission is examining the appreciable adverse effect of competition in India in the relevant market, which
And
has
IPs,
which affects even a common consumer.
IPs will have to optimize the CRP timeline to ensure that all this fits within the
Absolutely,
330 days at least. We'd
absolutely.
like to conclude on that. We apologize that we run a bit longer on
No,
the.
yes, our apologies that we could not deal with the second judgment very, elaborately. Otherwise, that is also a very interesting judgment, and Competition Act being a very interesting piece of legislation, which has, wide contours. I
Ramifications
would say
across.
absolutely wide contours.
one more webinar to deal with that case of.
Very well, very well.
Yeah.
I would be, quite delighted to do so.
Yes, sir, we will be. Now we have with us C. Rajesh Sharma sir, who is the vice chairman of the committee. Rajesh Sharma sir. Rajesh Sharma sir, are you there?
Sir, if you are speaking, you're on mute, sir. Rajesh, sir.
He's just busy over call. In the meantime, I would like to thank all the three speakers online.
Is there, ma'am?
Sir,
Is there?
good afternoon, sir. Good evening.
Good evening, sir.
My side, I am thankful to all the speakers who had delivered such a great lecture, and I can say who have enriched all the knowledge of all our fellow persons who had participated, and on a topic which was so recent, on a decision which was so recent. I even congratulate Sarika for taking a webinar so fast, so that benefit is taken from each and everyone. So that is the thing. So I congratulate again our board and all the speakers who are associated with it, and all the attendees who have taken advantage of it. And in future also, whenever something new comes up, definitely we will be taking it up at an earlier, so that you get abreast with all the latest thing which is going on in the whole insolvency and valuation area. Thank you very much.
Thank you, sir. Thank you.
I would personally like to thank Rajesh Sharma sir also to spare his valuable time and who could join at least in vote of thanks. So in absentia, CA Chand Mishra sir, who is the chairman, Rajesh Sharma sir, all the speakers of today's session, IP Sivalingam sir, Surya Narayana sir, and Badri sir. So, and with this, I would also like to thank each one of the participants who have been continuously there to listen to this judgment, who is which is very technical. You have also dealt in nitty-gritties, but to understand the judgment also, there is a lot of patience as well as lot of time is required to understand. So, on behalf of Insolvency and Valuation Standards Board, I would like to thank each one of you who have participated and the faculties and resource persons who have taken this session. Thank you so much.
We would like to thank you and your team for doing
Yes.
this day in and day out, 24/7.
I thank you, for inviting me, to share whatever little that I know. Thank you.
Thank you, sir.
Thank you. Have a great day. Bye-bye.
Yeah. Thank you. Bye-bye.